Ang susunod na programa ay rated G. Ito ay pwede sa lahat ng manonood.
Understanding Political Law Made Easy. So, I'm Chris Pante and we will discuss political law and the 1987 Constitution of the Philippines together with my 6 resource speakers. So, this show is created not only to discuss but also to inspire fellow aspirants in the field of law. So, to connect more with our televiewers, magsasalita rin tayo ng Filipino para mas maintindihan natin ano ba talaga ang political law. So tonight, we will be citing some provisions from the Constitution and the Book of Attorney Rolando Soto. So let's start by defining political law and other law such as administrative law, election law, law of public officers, and law on municipal corporations. So, political law. Political law is the branch of jurisprudence which treats of the science of politics or the organization of government. Our Supreme Court defined political law in more specific terms by saying that it is the branch of public law which deals with the organization and operation of governmental organs of the state and defines the relations of the state to the inhabitants of its territory. Philippine political law, on the other hand, deals specifically with the study of the structure and powers of our government, as well as the study of constitutional law, administrative law, election law, law of public officers, the law of municipal corporations, all of which are covered and included in the study of Philippine political law. Administrative law. It is a study of the laws that regulate the administrative organization and operations of the governmental organs of the state and determines the competence of the administrative authorities and the remedies available to an individual in case of violation of his rights. So, election law, it is a study of the laws, rules, and procedures involving the conduct of election of all public officials who will exercise the powers of government as allocated and within their function and responsibilities. Law of public officers, it is a study of the creation, modification, and dissolution of public office as well as the eligibility of public officers, the manner of their election or appointment and assumption of office, their rights, duties, powers, inhibition, and liabilities, and the modes of terminating their official relations. So, law on municipal corporation. This is a study of the general principles governing municipal corporation, the laws affecting the creation, organization, and government of provinces, cities, municipalities, and barangays, the scope and application of the powers of municipal corporation, including municipal ordinances, contracts, liabilities, and enterprise. So we're back, televiewers, and welcome sa aming program, Shara.
Thank you, Chris. Hello sa ating mga manonood dyan.
So narito tayo ngayon sa part 1 ng ating program. Ang topic natin for tonight is Philippine Constitution. So, Miss Shara, what is Constitution and its basic principles?
So yun, sobrang interesting talaga ng topic natin tonight. Di ba, Chris?
Oo.
So yun, bago natin simulan tong discussion natin about Constitution, kailangan muna natin i-define kung ano ang Constitution. So, according to Cooley, Constitution is a body of rules and maxims in accordance with which the powers of sovereignty are habitually exercised. In Marcos versus Manglapus, the Supreme Court defined Constitution as law for rulers and people, equally in war and peace, and cover with the shield of its protection all classes of men at all times and under all circumstances. It is simply called as the social contract doctrine. So, since na-define na natin kung ano ang Constitution, magtungo naman tayo kung ano yung basic principle na sinusunod ng ating Constitution. So first, the Constitution is the supreme law of the land. Ano bang ibig sabihin nun? Ibig sabihin, the Constitution direct from the people acting in sovereign capacity, hence, it is more superior to an ordinary law or statute. So, in simplest term, no man-made law, therefore, can prevail as against the Constitution. So, sinabi natin na ang Constitution ay supreme law of the land, ibig sabihin, Constitution serves as the symbol and monument of the people's will. As such, it should be submitted for ratification of the people following the Section 1, Article 2 of the 1973 and 1987 Constitution that sovereignty resides in all people and all government authority emanates from them. And third, the Constitution outlines the infrastructure of the government. Since the Constitution outlines the infrastructure of the government, it means that the fundamental powers of the government are established, limited, and defined under the Constitution. And because of this, the powers of the government are distributed among the several departments of the government for the safe and useful exercise of the laws under the Constitution. And fourth, huwag natin kalilimutan that the Constitution must be obeyed by all. So, hindi lang ito nag-a-apply sa isang tao or sa katayuan ng isang tao. It governs the poor and the rich. The Constitution governs the mighty and the weak, regardless of the color, religion, and political persuasion. And pinakahuli, lagi natin tandaan that the court are the ultimate guardian of the Constitution. Meaning, it is the court that implements the law prescribed in the Constitution, which would certainly give the people whatever is just and fair, as the case may be. So, yun Chris, siguro may natutunan naman ang ating mga manonood sa simpleng definition at sa katanungan na kanilang ibinato sa atin.
Siyempre naman, salamat Bishara. Napakalinaw, napakaganda. At sana po may natutunan kayong aral and ma-retain po iyon sa inyong mga isip. Salamat po.
Maraming salamat sa ating mga viewers.
So we're back, televiewers, and welcome Miss Julie sa aming program. So napag-usapan namin kanina ni Miss Shara na ang Constitution daw is the supreme law of the land. So, pwede ba itong baguhin?
Yan ang pag-uusapan natin tonight, please. So, according to Article 17 of our Constitution, pwede itong mabago by amendment or by revision. So, revision is the rewriting of the whole instrument. While ang amendment naman ay ang change or alteration lang doon. So, ang main difference sa revision, there will be an altering of the substantive entirety of the whole instrument, habang sa amendment naman, walang alteration sa basic principles doon. So, para malaman kung amendment or revision, meron tayong dalawang test na tinatawag. So, ito ang quantitative test or ang qualitative test. So, sa quantitative test, we will check kung substantive entirety ba ng instrument ang mababago. While sa qualitative test naman, titingnan natin kung merong pagbabago sa fundamental principles or fundamental framework doon sa Constitution. There are two steps in the process of amendment or revision, either by the Congress or by the people. So under the Congress, it may be under the CONCON or ang Constitutional Convention or ang CONAS or ang Constituent Assembly. At yung pangatlo naman ay ang People's Initiatives. Ngayon, may mga requirements para mag-qualify ang mga ganitong modes. Una, ang CONAS, ang 3/4 ng Congress ang magboto para sa amendment or revision. So, under the CONCON, there must be 2/3 of the votes of all the members or majority of its members must submit to the electorate the question of calling the CONCON. And third, in the People's Initiatives, it must be in a written petition, and then 12% of the total registered voters in the whole Philippines must take part therein. And out of that 12%, at least 3% of each legislative district must participate. So ngayon, ang kailangang pinakatandaan natin dito under the People's Initiatives, only the amendment is applicable. Ibig sabihin, hindi pwedeng mag-affect ang revision dito. Under the CONAS or the CONCON, the substance of the proposal is not subject to judicial review and left to the wisdom of the CONAS. However, the manner of making the proposal or the calling of the CONCON is subject to it. Ibig sabihin, pwedeng questionin or pwedeng himayin ng korte kung okay ba or tama ba ang naging manner ng pag-propose at ng pag-assemble during the CONCON. So on the other hand, under the People's Initiatives, propositions can be declared null and void if it violates the Constitution. Also, under this, revision cannot be made through initiatives or referendum. So ano nga ba itong initiative and referendum? First, the initiative is actually the people's initiative. So this is the power of the people to propose amendments to the Constitution or to propose and enact legislation. On the other hand, the referendum is the power of the electorate to approve or reject legislation through an election for that. So unlike in initiatives, there can be no referendum on Constitution and is only applicable to the statutes or the local law. So lastly, the second step in the amendment or revision is the ratification. So basically, this is to validate that amendment or revision. So there are three requisites in the mnemonics PRC. So P for plebiscite, R for registered voters, and C for community supervision. So here, there is a doctrine called Doctrine of Proper Submission. So here, people must be sufficiently informed of the amendments to be voted upon. So bawal ang piecemeal amendment because this will be unconstitutional.
So, komplikado pala yung proseso para mabago ang Constitution, Julie, di ba?
Tama yan, please.
So, to summarize, 1987 Constitution may be changed through amendment and revision. So, under Article 17, the two-step process involves the proposal and ratification. Proposal may be done through Congress, through CONCON, or CONAS, and by People's Initiative. Thank you, Miss Julie. Napaliwanag mo maayos yung topic, and sana maraming natutunan yung mga listeners natin and yung televiewers. We'll be right back. So, we're back again, televiewers. Nandito na naman po tayo ngayon sa ating third part ng ating program. So, our new speaker for tonight, live from Catanduanes, Miss Yani Tesorero. And she will be sharing her insights and knowledge about Bill of Rights.
Good evening, televiewers. I am going to discuss Bill of Rights found in Article 3 of the 1987 Constitution. We have 22 rights, and our first right is our right for due process of law and equal protection of the laws. According to Dean Rolando Suarez in his book Introduction to Law, due process is a guarantee against any kind of abuse by anyone in the three branches of government. The purpose of due process is to prevent undue encroachment against life, liberty, and property of individuals, to secure the individual from arbitrary exercise of powers of government unrestrained by the established principles of private rights and distributive justice. And our third is to protect the property from confiscation by legislative enactments, from seizure, forfeiture, and destruction without trial and without undergoing judicial procedures. The Due Process Clause should be interpreted as a substantive guarantee and as a procedural guarantee. Substantive due process means that if a law is invoked to take away one's liberty and property, there is a need to know whether the law is a proper exercise of legislative powers. Procedural due process is a guarantee to obtain a fair trial in court of justice according to the mode of proceeding applicable to the case. There are two aspects of procedural due process. One is in administrative proceedings and the other is in judicial proceedings. The requirements of due process in administrative proceedings as laid down in Antibay versus Court of Industrial Relations are as follows. First is the right to hearing, to present one's case, and to submit evidence in support thereof. Second is the tribunal must consider the evidence presented. Third is that the decision must have something to support itself. Fourth, the evidence must be substantial. Fifth, the decision must be rendered on the evidence presented at the hearing, at least contained in record or disclosed to the parties. The sixth is that the tribunal must act on its own independent consideration of the law and facts of the issue and not simply accept the views of a subordinate in arriving at a decision. The seventh is that the board should render its decision in such manner that the parties to the proceedings can know the issues involved and the reason for the decision rendered. The requirement of due process in judicial proceedings as laid down in Banco Filipino versus Palanca are as follows. There must be an impartial court with judicial power to hear and determine the matter before it. Second is that jurisdiction must be lawfully acquired over the person of the defendant or over the property which is subject to the matter of proceeding. The defendant must be given an opportunity to be heard, and judgment must be rendered upon lawful hearing. Our second right is our right against unreasonable search and seizure. Section 2 actually speaks of two rights. The first one is for the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And the next one is to not be issued search warrant or warrant of arrest unless there is a probable cause determined by the judge. Our third right is our right for privacy of communication and correspondence. According to the Constitution, this shall be inviolable except upon lawful order of the court or when public safety or public order requires otherwise. Any evidence obtained in violation of these or the preceding section shall not be admissible for any purpose in any proceeding. One example of this is wiretapping. Wiretapped evidence is not accepted by the court in all its proceedings. The constitutional protection for privacy or to privacy covers tangible objects such as letters, telegrams, files, and intangible objects such as audio recording or tape recording, etc. Our fourth right is the right to freedom of speech and press. According to in Section 4, it states that no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. Freedom of speech means that the people can utter or publish anything that they please, provided that it does not imply blasphemy, obscenity, scandalous character, public offense, falsehood, or malice. The right for speech and expression includes the following: the free speech and expression, like I mentioned before, and then the right for peaceful picketing or strike, the right for lawful strike, the right to disseminate information concerning facts of a labor dispute. The expression is by means of radio, television, motion picture, and by any other multimedia platform. The right to express grievances against the government and to criticize the affairs of the government. The right to display posters, notices, flags, and banners. Our fifth right is our right to religion. We have the freedom to exercise and enjoy religious profession and worship without discrimination and preference. Our sixth right is the liberty of abode and travel. We have the right to have a home and to maintain and change it. We also have the right to travel anywhere except if there is a threat to national security, public safety, or public health. Our seventh right is our right to information. It covers all matters of public concern and the access to official records, to documents and papers pertaining to transactions, official acts, decisions, as well as to government research data used in basis for policy development. However, there may be limitations set by statutory, a law, or any regulation which a particular office may impose to maintain order, efficiency, or to ensure safety of the records. Our eighth rights is our right of association. It is actually a part of freedom of expression and assembly, and it is also a subject. It is also subject to limitations and to dominant police power of the state. Our ninth right is our right against taking of private property for public use without just compensation. A private property can be used for public use only if it satisfies the following conditions. First, if the private property is taken for public use. Second, the owner should be paid just compensation. Third, due process should be observed in taking the property. And fourth, the taking of property should only be exercised by the state or by those to whom the power has been lawfully delegated. Our tenth right is our right to as a prohibition against impairment of obligation of contracts. Under Article 1306 of the new Civil Code, the contracting parties are free to enter into any kind of contract and they're free to establish stipulations, clauses, terms, and conditions as they may deem convenient, provided that they are not contrary to laws, morals, good customs, public order, or public policy. The freedom of contracts is both a constitutional and a statutory right. Our 11th right is a right to free access to courts and quasi-judicial bodies and adequate legal assistance. This is a collective responsibility of all lawyers, judges, prosecutors, legislators, and executive in the government. They have the responsibility, or they should not deny any service to anyone by reason of poverty. Dean Suarez distinguished indigent and pauper in his book Introduction to Law. Indigent is one who is authorized by court to prosecute his action and defense as an indigent person upon ex parte application and hearing showing that he has no money or property sufficient and available for food, shelter, and basic necessities for him and for his family. And pauper is a person so poor that he must be supported at public expense. According to the Supreme Court, the fact that a man is able bodied is enough proof that he has a sufficient means to prosecute an action or to secure the costs. 12th is our right to remain silent and to have competent and independent counsel. Any person under investigation has a right to be informed of his right to remain silent and to have competent and independent counsel. This is to prevent coercion, of course. If a person cannot afford the services of a counsel, he must be provided with one. 13th is our right to bail. This does not apply to those charged with offenses punishable by reclusion perpetua. The purpose of bail is to relieve the accused from imprisonment until his conviction and at the time his appearance at the trial is secured. 14th is our right to due process in criminal proceedings. In paragraph 2 of section 14, it states that the accused shall be presumed innocent until he is proven otherwise. He shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial, and public trial, to meet the witnesses face to face, to have compulsory process, to secure the attendance of witness and the production of the evidence in his behalf. However, after arraignment, trial may proceed notwithstanding the absence of the accused provided that he has been duly notified and his failure to appear is unjustifiable. Our 15th is the privilege of the writ of habeas corpus. The writ of habeas corpus is an order directed to a person detaining another and commanding him to produce the body of the prisoner at a certain time and place with the day and the cause of his detention. Under Section 1, Rule 102 of the Revised Rules of Court, the writ of habeas corpus extends to all cases in illegal confinement of detention or by which any person is deprived of liberty or by which the rightful custody of any person is withheld from the person entitled thereto. 16th is our right to speedy disposition of cases before all judicial, quasi-judicial, and administrative bodies. It covers all phases of proceedings, whether judicial, quasi-judicial, or administrative. This right covers also civil, criminal, or administrative cases, unlike in Section 12, where it covers only cases in criminal prosecution and is in trial stage. The 17th right is our right against self-incrimination. This right is a mandatory substantive right established on broad grounds of public policy and humanity. The purpose of the right against self-incrimination are to prevent witness or the accused from being coerced physically, morally, or psychologically into incriminating himself. And the second is to protect the witness from committing perjury because the first law of nature is self-incrimination. Um, this right is applicable to all cases, whether civil, criminal, or administrative, and may also be claimed by witnesses who is asked an incriminating question. Our 18th right is our freedom for political belief and freedom against involuntary servitude. According to Section 18, no person shall be detained solely by reason of his political beliefs and aspirations. No involuntary servitude in any form shall also exist. Involuntary servitude is a condition where one is forced to work against his will, whether he is paid or not. Involuntary servitude, however, is permissible only if, as stated in Section 18, if it is a punishment for a crime that he has been convicted, and if it is so required to defend the state, and if it is so needed under the principle of posse comitatus. Our 19th right is our right against excessive fines and degrading inhuman punishment. A fine is considered excessive if it is clearly shown that the nature of the violation compared to the fine is disproportionate. Likewise, punishment is cruel if it is flagrantly and plainly oppressive, wholly disproportionate to the nature of the offense. or when it involves torture of lingering death. The 20th right is our right against imprisonment for debt or non-payment of a poll tax. In Villanueva versus City of Iloilo, poll tax was defined as a tax of a fixed amount upon all persons or upon all persons of certain classes resident within a specified territory without regard to their property or the occupations in which they may be engaged. The 21st is the no double jeopardy. As defined by jurisprudence, no double jeopardy means that a person cannot be charged with same or identical crime when such person was previously acquitted or convicted of a similar crime. The requisites to constitute double jeopardy are: first, it has to have a valid complaint or information. Second is that the complaint or information must be filed in a court or a competent jurisdiction. Third is that the accused has pleaded guilty to the charge. And the fourth is that the accused has been acquitted or the case dismissed or terminated without his express consent. Our last right is the right against ex post facto law and Bill of Attainder. Ex post facto law, as comprehensively defined by the Supreme Court, is one which makes an action done before the passing of the law and which was innocent when done. Criminal and punishment punishes such action or aggravates a crime or makes it greater than it was when committed, or changes the punishment and inflicts a greater punishment than the law annexed to the crime when it was committed, alters the legal rules of evidence, and receive less or different testimony than the law required at the time of the commission of the offense in order to convict the defendant, assumes to regulate civil rights and remedies only, but in effect imposes a penalty of deprivation of right which when done was lawful, or deprives a person accused of a crime of some lawful protection to which he has become entitled, such as protection of former conviction or acquittal or a proclamation of amnesty. The characteristics of an ex post facto law are as follows: it refers to criminal matters, it is retroactive in application, it alters the situation of the accused to his advantage, to his disadvantage, rather, it works to the prejudice of the accused. That the scope and the applicability of the prohibition against ex post facto law are criminal legislation which affect the substantial right of the accused, and the criminal procedure law prejudicial to the accused. The Bill of Attainder in People versus Ferrer was described by the Supreme Court as a legislative act which inflicts punishment without trial. Its essence is the substitution of a legislative for a judicial determination of guilt. The characteristics of Bill of Attainder and Bill of Pains and Penalties are: first, they are convictions and sentences pronounced by the legislative department instead of the judicial department. And the second is that the sentence pronounced and the punishment inflicted are determined by no previous law or fixed rule. And the third is that the investigation into guilt of the accused, if any such was not necessary or generally conducted in his presence or that of his counsel, and no recognized rule. So that, my dear televiewers, is the Bill of Rights.
So, thank you, Miss Yani Tesorero, for that very informative insights about the Bill of Rights. So, stay tuned, televiewers, and we'll be right back. So again, we're back, televiewers. Welcome po, Miss Marfil. Miss Marfil, ano ba ang fundamental and inherent powers of the state?
First of all, I would like to say hi to all our viewers. So, good evening. So, basically, there are three fundamental and inherent powers of the state. So, Chris, first is the police power. This is the power vested in the legislature by the Constitution to ordain, make, and establish all the manner of reasonable laws, statutes, and ordinances, either with penalties or without penalties, by not repugnant to Constitution. And also, it is the sovereign power to promote and secure the protection of the general welfare. The police power is based on the legal maxim, which is salus populi is suprema lex, which means that the voice of the people is the supreme law. Secondly is the power of eminent domain. It is the right of the state to acquire private property for public use and upon payment of just and full compensation and observance of due process. Lastly, the power of taxation. It is the inherent power of the state to raise revenue to defray the expenses of government or for any public use. And this can be done through imposition of burdens or imposition of on persons, property, services, occupations, or transactions. Also, power of taxation, also known as the lifeblood theory or necessity theory. It constitutes with theory of taxation which provide the existence of government is a necessity that cannot continue which without means to pay its expenses, and that for that this means it has right to compel all its citizens and property to contribute to our government.
Miss Marfil, ano ba ang similarities ng powers of the state?
There are 5 similarities of the three inherent powers of the state. So it can be easily remembered in this code. The EL or triple IEL. So first I is the interference, which the three inherent power methods interferes the private rights. And second I is the inherent. The three inherent powers can be exercised without the need of express constitutional grant. The third I stands for indispensable and indestructible. And fourth is the E, which stands for equivalent compensation. And the fifth is the L, stands for legislative in character. So, it can be exercised by the legislature.
So, Miss Marfil, what is the difference between the three inherent powers of the state?
So, there are 4 differences between the three inherent powers of the state. So, first is as to the nature of the compensation. So, as to the nature of compensation in taxation, there is a protection and public improvement for the taxes paid by the citizen of the state. Second, as to the nature of the property, in police power, it involves destruction and confiscation of property which are unlawful and noxious. And in eminent domain and taxation, the property taken is for public use. As to how the power is exercised, in police power and taxation, inherently exercisable only by the government or the state. In eminent domain, it may be exercised by the private entities but upon valid delegation. And lastly, as to what is regulated. In police power, it regulates liberty and property. And in eminent domain and taxation, they are addressed to private rights only. So, that's all. Thank you.
So, yun na po. Thank you, Miss Marfil, for that wonderful and knowledgeable discussion. Thank you po sa panonood ninyo. So we're back again, televiewers. And nandito na naman tayo ngayon sa ating part 5 ng ating program. And nandito ngayon si Mr. Solano, and they're going to tackle about impeachment. So, Mr. Solano, ano ba ang impeachment and ano ba ang mga nakapaloob dito?
Maraming salamat, Chris, sa unang sa pag-imbita sa amin dito sa iyong programa. At sa iyong katanungang impeachment, ito ay isa sa pinakamagandang topic na kailangan na malaman ng bawat Pilipino. Ano nga bang impeachment? Ang impeachment ay isang pamamaraan ng pagtatanong. It is a method of national inquest into the conduct of public men. And it is referred to as an extraordinary process of removal exercised by the legislature over a selected member of officials. Maraming nagtatanong, sino-sino nga ba ang mga impeachable officials under the 1987 Constitution? Una, ang presidente. Pangalawa, vice-presidente. Pangatlo ay members of the Supreme Court. Pang-apat ay mga members ng constitutional commissions. Ngayon, magtatanong tayo, ano ba ang mga grounds for impeachment? So, the grounds for impeachment are, number 1 is the culpable violation of the Constitution. Number 2, treason. Number 3 is graft and corruption. Number 4, other high crimes or betrayal of public trust. Isa-isahin natin ngayon, Chris. Ano nga ba, or what is culpable violation of the Constitution? Well, it is defined as wrongful or intentional or willful disregard of the fundamental law. The act must be deliberate and motivated by bad faith to constitute a ground for impeachment. Kailangan ginawa nila. There is an overt act to do or to disregard the fundamental law. And a mere mistake in the proper construction of the Constitution cannot be considered a valid ground for impeachment. Ang pangalawa, what is treason? Treason is a crime committed by any person who, owing allegiance to the government of the Philippines, levies war against it or adhere to its enemies, giving them aid and comfort. Nagtraidor o pagtatraidor sa ating bansa. Pangatlo, what is bribery? It is a crime committed by any public officer who shall agree to perform an act, whether or not constitute a crime, or refrain from doing an act which he is officially required to do in connection with the performance of his official duties, in consideration of any offer, promise, gift, or present received by him personally or through the mediation of another, or who shall accept gift offered to him by reason of his office. Pangatlo, what are other high crimes na sinasabi? They are to those offenses which, like treason and bribery, are of so serious and enormous a nature as to affect the very life of the orderly workings of the government. Sabi nga ni Justice Cruz, though rape and murder, although as serious as treason and bribery, hindi siya pwedeng ma-exclude from the definition of high crimes. Pang-apat, what are the acts that constitutes graft and corruption? Ngayon, yan ang mga sinasabi sa Anti-Graft and Corruption Practices Act, which was enforced at the time of the adoption of the Constitution, Section 3, RA number 3019. Panghuli. Well, it is a ground for added by the Constitution Commission, presumably to cover all the offenses and becoming a public functionary but not punishable by criminal statutes.
So yun pala ang mga grounds para makapag-file tayo ng impeachment against corrupt officials. So ngayon naman, ano yung mga procedures in order for a person, a certain individual, to file an impeachment complaint against these corrupt officials?
Well, Chris, you have to have a strong case against the public official that holds the position. Section 3 of the Article 11 of the 1987 Constitution dictates the procedure of impeachment. First, the House of Representatives shall have the exclusive power to initiate all the cases impeachment by a vote of 1/3 of its members. So right now we have 304. So you have to have 103 or more than that to initiate the impeachment.
Okay.
Secondly, the Senate has the sole power to try and decide all cases of impeachment. So, the Senate will act like a court. So, under the impeachment or trial in the Senate, no person shall be convicted without the concurrence or the approval of 2/3 of its members. So now, who can file a complaint of impeachment? Section 3, paragraph 2 of the Article 11 of the Constitution states a verified complaint. So, as any citizen, meaning, kahit mababa or nasa baba, pwede mag-file ng impeachment. Kailangan lang i-endorse na kongresista.
Ano pala yun?
So, the procedure, as I said, it will be in a form of resolution. First procedure, said resolution of endorsement shall be included in the order of business days within 10 days and refer to the proper committee within 3 session days thereafter. Second, the committee, after the hearing and by majority vote of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. Third, the resolution shall be calendared for consideration by the House within 10 session days from receipt thereof.
So, may question lang ako, Mr. Lara. So, can an impeachment proceeding be initiated against the same official more than once within a period of 1 year?
No, Chris. Because it states that in Section 3, Paragraph 5, provides that no impeachment proceedings shall be initiated against the same official more than once within that year. So it won't appear, so it will prevent the impeachment as a form of harassment. Who shall have this sole power to try and decide all cases of impeachment? So, actually, the first one that would come into mind is the judicial power. Actually, no, it's the Senate. The Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senators shall be on oath or affirmation when the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of 2/3 of all the members of the Senate. So, if the Congress requires 1/3, the Senate requires 2/3 of its members.
So, what is the nature of the impeachment proceedings?
Page 318, third paragraph of Political Law by Justice Isagani Cruz, he said that impeachment proceedings are in sense judicial and penal in character. The constitutional rights of the accused as guaranteed in Article 3, such as the right to due process and against self-incrimination, are available in these proceedings.
So, again, another question. So, what rules apply in an impeachment proceeding?
The rules of the rules of court shall supplement the rules of the Senate whenever it's practical. So, the Senate has its own way of proceedings. The proceedings in a regular court or the Supreme Court, like the rules of court, would be only supplementary to them.
So, what is needed in order to convict the person subject of impeachment?
Section 3, paragraph 6 provides that no person shall be convicted without the concurrence of 2/3 of all the members of the Senate.
So, what is the effect of a judgment in case of impeachment?
First, or she will be removed in office. So she will or he will be stripped down by his or her power. Second, that person will now be disqualified to hold any positions in the government. Third, in addition, the party convicted shall nevertheless be liable or subject to prosecution, trial, and punishment according to law. So now, as he or she was stripped down of his or her power, she will now become a regular person. Like in case of the president, Rodrigo Duterte, he's still immune to any regular case.
If nasa position pa siya.
Yes.
So, ganun na nga.
Only the grave offenses or impeachable complaints to the president.
Can be a grounds for impeachment.
Yes.
Thank you po, Mr. Lara, Mr. Solano, for that very informative lecture. So, stay tuned and we will be right back. So, thank you po sa inyong mga nanood, sa mga televiewers, and sana po may napulot po kayong mga aral, and may apply niyo po ito in the future. And salamat po sa aming prof, si Attorney Noble, for making this report possible. And good evening, everyone.